So I'm going to go through the survey, and I am going to not cover every single slide because there are 24 slides, I believe. There are approximately 25 or more laws still on the books in Oklahoma regarding the issue of abortion. And so let me see, make sure, which direction do I push this? Yeah, well, yeah, this isn't moving. Okay, so as you see each of these slides, you're going to see topics up here, and they are going to involve specific laws that are on the books in Oklahoma. And I'm going to make a few comments about them. And I only have about 30 minutes, so I'm going to go through this fairly quickly. But what I want to point out is that this all stems from the case, as you are well aware, of Dobbs versus Jackson Women's Health Organization that was announced from the U.S. Supreme Court on June 24th, 2022. And as you all know, that changed dramatically the situation in all 50 states regarding the legality of abortion. Oklahoma had an old law on the books, Title 21 OS 861, which was a criminal code that was in effect at least as far back as 1910. The legislature in Oklahoma actually enacted a bill this year that became effective on June 24th. It was a trigger, as we call a trigger bill, and you'll probably hear about this around the country and when you read articles about other states. And what the trigger bill did was basically bring this law up to date. They did not just keep the law as it was written in 1910. In fact, it was modified at least once between 1910 and today. But they went back to basically the 1910 language to make this a felony for anyone who administers an abortion or prescribes medication, basically with the intent to procure the miscarriage of such woman unless it's necessary to preserve her life. And this was a potential felony punished by 2 to 5 years in the penitentiary in Oklahoma. So what happened after that was, in the same legislative session, the legislature also enacted another bill that was effective on August 26th of 2022. In the meantime, there were 2 bills that became effective in May of 2022. And so these all sort of work together. You can go ahead. And so the next slide deals with some of these other bills that came into effect. This is the bill, the August bill, that is now effective in Oklahoma, that now makes it a felony with up to 10 years imprisonment and up to a $100,000 fine. And that is basically the same sort of law as modeled after the original criminal code, but there are some additional provisions to this. Meanwhile, the other statute was not repealed. So go forward one more slide. So what has happened between June 24th, when Dobbs came down, and then August? There were 2 bills that became effective in May of 2020, and they dealt with civil actions against physicians. And there were 2 bills that were basically, one is a House bill, one is a Senate bill. They were both enacted within 23 days of one another, and they are nearly overlapping. They provide for up to $10,000 in statutory damages for a private lawsuit. These were both modeled, as much as we can tell from the press, after the Texas civil actions. And so you have two separate bills that came into effect in May. So we have the felony that was effective in June. So in May, we went to a civil enforcement system in Oklahoma. I mean, this is all ancient history right now because, of course, we're in October, but the problem being is none of these laws have been repealed in the state of Oklahoma. So we have civil action that was effective in May, when abortion was still allowed in Oklahoma under strict circumstances, but before Dobbs came down. And so then after May, we have the August 26th law, which then is more stringent and a harder penalty, 10 years and $100,000. So what the Attorney General, and the Attorney General in the state of Oklahoma is the statutory highest law official for the state of Oklahoma, representing the state of Oklahoma. And the position that the Attorney General takes is that once Dobbs was enacted in June, that before that, there were civil penalties in place to make sure that anyone who tried to perform an abortion at all and from May on was subject to civil penalties, except in certain circumstances, there were exceptions. And then after August, that the August bill, which is the higher penalty, comes into effect. And so the Attorney General is of the opinion that basically we are now guided by the statute that is the $100,000 penalty and up to 10 years. If you want to go forward, we'll go to the next group of statutes. Let me give you what the definition of abortion seems to be. This seems to be the most reoccurring definition in all these statutes. Abortion means the act of using, prescribing, administering, procuring, or selling of any instrument, medicine, drug, or any other substance, device, or means with the purpose to terminate the pregnancy of a woman, with knowledge that determination by any of those means will, with reasonable likelihood, cause the death of an unborn child. It does not include the use, prescription, administration, procuring, or selling of Plan B, morning after pills, or any other type of contraception or emergency contraception. All right, there also are exceptions, and these are all, this is the definition that was found in the May statutory enactments in Oklahoma. And so the issue that we have now is that we have all of these competing things. We have many, many competing things going on. We also have, in this slide, we also have some other things that are going on. Before we got to, well, actually also in May of this year, there was a fetal heartbeat ban that came in. And this was the basis of then the civil action. So Oklahoma banned abortions after there was a detectable heartbeat. We have a couple of different statutes that mention the heartbeat. And so you could then have a civil action if you performed an abortion after the heartbeat law came into effect. So basically, Oklahoma has banned abortion since the spring of this year in the state of Oklahoma, even before Dobbs, with multiple layers of statutes. So the problem that we have, of course, we are dealing with statutes that have some exceptions. Even the felony statute has an exception for the life of the mother. But we have some other statutes that are still on the books that also deal with some other types of exceptions, including rape and incest, and some other things that might be a medical emergency. We start seeing the phrase medical emergency in many of these statutes. So the other interesting thing was, in 2021, the legislature actually enacted a bill that would have repealed everything but the felony statute, the old felony statute. And then when they got to 2022, they decided they did not want to repeal all these other multiple statutes. So before that repeal went into effect, they repealed that bill. So that's why we still have at least these 25 or more. I think there are more than this because there are other things that deal with just registration and some other administrative things. So we have all of these laws still on the books in Oklahoma. So let's go forward to the next slide. And again, this is another statute that has a number of criminal penalties associated with it. And this statute was enacted to require that only an OB/GYN be the one who performed abortions. Again, that is still on the books. That was on the books before we got to even the heartbeat. And we have a couple of the heartbeat things. And if this sounds confusing, it's because it is confusing. It's very confusing. And the thing that judges do, as opposed to attorney generals or politicians, is judges have to make sense of what's in front of them. And so in each and every one of these stages, we have cases that are pending. And if you go back to the materials, you can find in the chart, we included the case numbers of all the cases that are pending. And so as you go through the chart, if there's some particular law that you want to follow, for example, the 5 new laws that were effective in 2021 have all been challenged in a case of this court number 119918. This is pending in the Oklahoma Supreme Court. This deals with detectable heartbeat, deals with issues regarding the OBGYN involving abortion-inducing drugs. Also, it deals with the use of the abortion-inducing drugs, and there's a specific law in 2021 that came into effect that required all physicians and manufacturers to comply with the law, where they could be fined up to $250,000 as a physician or $500,000 as a manufacturer. There's another bill that was effective also that affects medical licensure, both for medical doctors and osteopaths. And again, these statutes in 2021 all had exceptions for to prevent the death of the mother or prevent a substantial or irreversible physical impairment of the mother that substantially increases the risk of death. So you see that phrase throughout 2021. Those cases are all, those challenges are all still pending. Now, we did back in 2021, October 25th, we did issue a temporary injunction so that these 5 bills, and they're identified as House bills and Senate bills, are stayed pending appeal. So the 5 that were passed in 2021 are still pending appeal and are on a stay order, and that is public record. So I cannot give you an opinion about how these things work together, but I can tell you that the slides that we've looked at, the first couple that deal with the criminalization of abortion, both the original Title 21-861 that was effective as a trigger law, and the later law, the one that came into effect in August that deals with up to $100,000 and 10 years in prison. Those cases are also under challenge right now and are pending in front of our court. We also have challenges to some statutes that came into effect in 2015. We have several cases there that involves, let me see if I can read this in a way that I understand what I'm saying. One of those in 2015 would delay abortions for up to 72 hours. That was a change over old law. And then there was also a ban on physicians from performing a particular procedure that is within the standard of care after 14 weeks of pregnancy. So we have a lot of things still on our plate, so to speak, in state courts. And this is true all over. If you followed Ohio, Arizona, there are several here that have multiple laws, and they have multiple challenges since Dobbs. So from a standpoint of sort of the rule of law, stepping aside from the topic, I just want to say that the idea of having precedent is important when you have a country and a society and a state that's based on the rule of law, because you have laws on the books, you have a certain stability, you have an expectation that judges will apply the law as written. If there are ambiguities, the law also allows the judges to interpret. But those are sort of the standard rules. And when something comes along that changes everything, and everything in Oklahoma for the last 50 years basically was geared toward a legal abortion. Increasingly from the 1990s on, there were more and more restrictions on when you could have an abortion and where, and whether you had to have hospital privileges, and there was a challenge to medicine abortions and whether you could be off script for one of the drugs, and then the FDA changed that and it was on script. I mean, we've followed all of these issues for all of these years with court challenges, both at the trial level as well as the Supreme Court. But there was a certain expectation that the Roe case and later the Casey case could be relied upon. And there is something in our Constitution, as well as in the US Constitution, that says that federal law, when it is in place in certain aspects of our society, and some of our rules are based on federal procedure, that there's basically a preemption by the federal law, and that we acknowledge the supremacy clause. So that was the basis of decisions in our court for a number of years, and of courts in the district courts for a number of years. So now everything has changed, everything has gotten more complicated. What I also want to point out, and if you have interest in finding out more about Oklahoma law, or you want to follow all of these cases, they are in the materials in the slides that are on the website. And I can read off another case number. It's case number 120543. That's pending. Case number 120376 is pending. Also, I mentioned 119918 is continuing to be pending. And then I think we have 118292. So we have a number of cases that, as I mentioned, they go all the way from challenges from this year, 2022, 2021, 2015, and there's some in between. So those challenges are all still pending at our court. One thing I want to point out in Oklahoma, back in the 90s, there was an attempt, or not 90s, 2012 actually, it seems like only yesterday. When I was in law school, you know, the teacher would look at something, a professor, and say, oh, this recent case would be 1965. And I was in law school in the 70s, and we're all going, what? Recent case? So anyway, 2012 seems very recent to me. In 2012, there was an attempt by the legislature to, through a referendum, to, and also by an initiative, to include in the Oklahoma Constitution what was known as the Personhood Amendment. This would have amended the Oklahoma Constitution based on a vote by the citizens of Oklahoma that a person defined in this Constitution shall be defined as any human being from the beginning of the biological development of that human being to natural death. The inherent rights of such persons shall not be denied without due process of law, and no person as defined herein shall be denied equal protection under the law due to age, place of residence, or medical condition. This is a very broad, vague statement. This was struck down by our court at that point because it was inconsistent with the Casey case. It was Planned Parenthood versus Casey. So that initiative did not make it to the ballot in Oklahoma. Fast forward to 2023, I have just, you know, you hear through the grapevine that there may be another opportunity for the legislature to be involved in the issue of abortion. It would not be surprising that this type of constitutional provision will not only be proposed in Oklahoma, but perhaps in some other states. There is also discussion, just, you know, that discussion that you can't figure out whether it's true or false, but it's just all over the place, that there will probably be another attempt at a referendum to ban abortion in Oklahoma. And there may also be another attempt at, or there might be a new attempt at an initiative petition to protect the right of abortion. So I just want to let you know that I've looked at some of the information that's around. Kansas, as many of you are probably aware, was the first state to put the question of abortion rights before the voters after June of this year, after Roe was overruled, and the voters in that state rejected the ballot initiative and preserved the state constitutional protection. Their Kansas Supreme Court had opined a couple of years ago, maybe 3 years ago, that there was a constitutional right to an abortion under the Kansas Constitution. California also is apparently looking at something that would amend the California Constitution to include the right to reproductive freedom, which would also include the right to have an abortion and the right to contraceptives. That would then be added to their state constitution, and the new section would read, the state shall not deny or interfere with an individual's reproductive freedom and their most intimate decisions, which includes their fundamental right to choose to have an abortion and their fundamental right to choose or refuse contraceptives. So that is also being proposed. Michigan has a ballot initiative on, it's called Proposition 3, which would amend their state constitution, the Michigan state constitution, to establish a new individual right to reproductive freedom. And that would be, actually, it's a very extensive proposal that would regulate abortion after 22 weeks. The state would be allowed to regulate abortion after 22 weeks, but it would also invalidate any state law that conflicted with the constitutional amendment. This is, at the last count on this, there were enough signatures had been turned in, but there was also still some things going on. And in September, a state court also invalidated their 90-year-old ban on abortion, which would have been probably a criminal statute similar to Oklahoma. Vermont is looking at this. They are proposing, there's proposed there a state constitutional amendment to provide the personal reproductive autonomy. There's also Kentucky is looking at whether or not they would pass an amendment that would not allow for any abortion, that would protect human life. And that is another state which has a number apparently of trigger laws. Montana is looking at adopting the Born Alive Infant Protection Act, which would impose criminal penalties on healthcare providers that do not take medically appropriate and reasonable actions to preserve the lives of infants. And the infant would also be defined as one who breathes, has a beating heart, or has definite movement of voluntary muscles. And so there are a number of definitions out there from a legal standpoint. I don't know how to exactly give anybody any guidance in this room, because as I mentioned, we have so many things that are pending here, and our court will consider all of the briefing, all of the legal authorities. You will see in the public record on in the files of these cases pending in front of our Supreme Court, there is at least one or more requests that our judges find that there's a constitutional right to an abortion in the Oklahoma Constitution. Let me just say on the record that to date, all decisions that were made before the Dobbs decision, our court has never found there is a constitutional state constitutional right. All those cases relied on the Supremacy Clause and on Roe versus Wade and Casey, Planned Parenthood versus Casey. So like I said, I can give you no opinion, no indication, no hint, no anything about where we will end up in Oklahoma. But just know that courts all over the country, states all over the country are dealing with these things, are struggling with these issues, are hoping to have some clarity. When you have 25 or more laws on the books, and each one of these acts, some of them are just one statute, some of them are 15 statutes. Some of them amend statutes that exist now, some of them create entirely new laws. But each one of these will be evaluated in the way that we would evaluate anything where we have conflicting issues in legislation. There's statutory interpretation. We don't even get to the Constitution. If there are conflicts in statutes, that is a legitimate reason to bring a challenge to a court, to the Supreme Court eventually, if statutes are conflicting. So we have a number of conflicting statutes. We have really a whole new world. It's a whole new world. Oklahoma is also still struggling, and you all, this has nothing to do with abortion, but it has to do with reservations in the state of Oklahoma. But in July of 2020, the US Supreme Court handed us a decision that said that all of the Indian law that we understood from law school and so forth, that the Allotment Act in Oklahoma, called the Dawes Act, had abolished reservations, was all wrong, and that the reservations are all still intact in Oklahoma. So that was another area where there was a lot of longstanding precedent. And we had a lot of things that we had an expectation that things would be decided in a consistent, uniform way. And that is all out the window. And then we also are still struggling with that case and the reservation issues and the autonomy and the sovereignty of the tribes. And we have 39 federally recognized tribes, and we have at least 6 tribes who have legal decisions already that say the reservations were restored by the McGirt case. So we have issues trying to resolve all those issues. We don't have any civil cases out of the US Supreme Court on this issue of reservations. We do have a subsequent case from the US Supreme Court that also happened this year that had to do with whether or not state courts had concurrent jurisdiction with federal courts and tribal courts and criminal matters. So we have all of these things. So there's another decision that the US Supreme Court is taking up later this year. I think they may have just had oral argument. It has to do with the Indian Child Welfare Act, which has been in effect since the late 70s and has allowed tribes and states and federal jurisdictions to work together to help children who are deprived and abused. There is a challenge to that in the US Supreme Court that is racially biased. And so I'm not predicting anything, I'm just saying that that's where we are in the legal world right now. That's where we are as judges. We have cast aside things that were static, understandable. There were nuances that had to be determined, but we had a certain stability. We do not have that stability when these types of cases are decided. I am not being critical of anyone. I am not taking any political view on any of this. I'm just saying, just like when you go to the store and they say, please be patient because we don't have enough help, right? We don't have enough employees. Please be patient. And that's really difficult because this is impacting the medical profession directly. But please be patient and understand that the judges in this state, as well as other states, we are all doing the very best we can to be judges and not to be politicians and not to be elected officials in the sense of our political elected officials. We are all doing our best to understand and try to work through these things, but it does take time and it will take time.